Welcome to the virtual orientation for incoming students in Common Law's English JD program. My name is Craig Forces. I'm Professor of Law at the University of Ottawa, where I teach a number of subjects including public international law, national security law, and administrative law. In this virtual orientation, we cover many of the issues and ideas that are necessary for you to fully appreciate and understand many of the topics you'll be dealing with in your first year of legal studies. And so in the course of the next several podcasts, I'll be interviewing some of the members of the University of Ottawa's teaching faculty, including those who teach in the first year. Of course, by virtue of the fact that these podcasts are 20 minutes or so in length, we can only grapple with these issues in a fairly succinct and summary fashion. Nevertheless, in this manner, we provide you with a table of contents, if you will, to some of the key aspects of the first year program. And this table of contents gives you an opportunity to understand the forest before you probe in greater detail the trees that constitute the subject matters of your first year courses. We have set up these podcasts much like one would set up an album on iTunes. And so you can pick and choose those podcasts you wish to listen to at any particular juncture. We have, however, tried to order and structure them in a logical framework. And so we invite you to follow them in sequence and listen and re-listen to them as your time permits. At the beginning of each podcast, I will provide a brief overview of the subject dealt with in that podcast and some sense of its relevance and how it fits into the broader whole that constitutes this podcast project. In this initial podcast, my intent is to provide you with an overview of the first year program. Not only will this help you understand why the materials covered in the podcasts are important, but it should help situate the more detailed information that we provide to you during your first few days in the law school itself in September. Let me begin by describing the basic architecture of the first year program. In the first year program, you study 9 courses for a total of 34 credits. Speaking generally, these courses can be divided into 3 broad categories. The first category of courses would be those that constitute private law. Private law being that aspect of the law that governs relations as between individuals, private citizens. Courses in this area include property, torts, and contracts. The second broad category of courses would be the public law offerings in the first year program. Public law being that aspect of the law that governs relations between the individual and the state. And so in this area, first year includes public law and legislation, Constitutional Law 1, and Criminal Law and Procedure. We then offer a thematic course in the second term of first year. And within thematic courses, there are an array of different subject matters on offer that do change from year to year. And in this area, you will find primarily public law courses, but also a number of private law offerings. The third broad category of courses that you take in the first year are those that are about principally skill transference. And so dispute resolution and professional responsibility and principles of legal research provide you with core elemental skills of essence to any functioning lawyer. Several of these courses are offered in a large group setting. That is, you take these courses in a class of approximately 70 to 80 individuals. However, with our so-called small group courses, those courses involve registrations in the order of 20 persons. And so one of the aspects of our program is that you choose to take either criminal law or torts in a small group setting. In that small group setting, you will focus not just on the substantive issues associated with criminal law or torts, but also you will be instructed in the area of legal writing. And so here there is a mix of both substantive and skill transference. Also, with the thematic courses, those offerings are capped at the 25-person level. Although in a handful of cases, there are thematic courses that are as large as 40 to 45. I want to pause at this point and describe in greater detail the content of some of these courses. I start with the caveat that the actual precise coverage will vary between professors. And you'll get some indication of that in the course description materials specific to each professor's class, which will be available to you prior to registration. Let me begin with contracts. For most of you, this is a fairly intuitive concept, but contracts is the study and analysis of the basic principles of contract law. And so the topics that are covered include conceptual and historical introduction to contracts, how contracts are formed, the operation of contracts, how one is discharged from contracts, remedies, and also an introduction to the concept of agency. Property is also a concept that should be fairly intuitive to most of you, although the actual content may be somewhat surprising. And so property focuses on issues of ownership and possession, and the law relating to what's known as real property and personal property. And under the heading of personal property, instructors will focus on such things as gifts and bailment, finders, and within real property, concepts such as tenure, contingent interest, estates, future interests, natural resources, water rights, and also, in our program, First Nations land law. A number of other issues will also be covered, depending on the preoccupation of the professor in question. Torts, another private law topic, involves liability for interference with the interests that persons may have in their own bodily integrity, their own property, their own reputation, their own economic interests. And so torts include such things as intentional torts, such as battery, and also concepts like negligence. Moving on to the public law courses, our introduction to public law and legislation focuses on the formation and purposes of legislation, the structure of the Canadian legal system, the federal legislative process and statutory interpretation, as well as basic doctrines associated with Canada's constitutional law, a law that is foundational to much of the rest of your legal studies. Also in play is the structure of Canada's courts and tribunal system and the role of the courts in overseeing both legislative and administrative action. Another public law topic is Constitutional Law 1. In the University of Ottawa JD program, constitutional law is divided into two different courses. And so you take Constitutional Law 1 in first year, and you will take Constitutional Law 2 in second year. In terms of the content, Constitutional Law 1 focuses on the Charter of Rights and Freedoms. And so it examines the framework of the Charter and covers fundamental rights and freedoms protected by the Charter, as well as dealing with constitutional remedies, and also, more generally, the sources of Canadian constitutional law and the role of the courts in policing that constitutional framework. Criminal law and procedure involves the study of general principles of criminal law, burdens of proof, the physical and mental elements of offenses, select defenses in criminal law, basic elements of criminal procedure, and also, again, depending on the preoccupations of the professor, the impact of the Charter of Rights and Freedoms on both substantive and procedural issues in Canadian criminal law. As the title suggests, dispute resolution and professional responsibility focuses on ethics, professional responsibility, legal problem solving, transaction facilitation, and dispute resolution through negotiation, mediation, and arbitration. It involves a substantial amount of practical, hands-on exercises that put you in the position of actually exercising these skills. And finally, principles of legal research involves an introduction to the fundamentals of legal research, including research techniques, bibliographical sources, and the rules of legal citation. As already noted, our thematic course, offered in winter term, involves any number of different subjects and different courses from which students may select. Courses cover such things as environmental law, technology law, and issues surrounding legal history and legal theory. There is also the prospect of studying public international law. In fact, studying public international law in the first year program is compulsory for those students who are enrolled in the joint JD MA program with the Norman Paterson School of International Affairs. That, in a nutshell, is the first year program. I want to say a few words now about managing your first year program to maximize your prospects of success. I do so in my personal capacity as a professor for the last decade. and as the incumbent vice dean at the time in which this podcast is recorded. My views are personal views. They may not be shared, at least in full, by my colleagues. However, they reflect my personal observations over the course of my career. The first point I'll make is to temper your expectations. The admissions average for the University of Ottawa JD program is in the A- range. And so that means that the colleagues who sit with you in your classes have, on average, an entry-level GPA in the 80 to 83 percentile range. In these circumstances, you will find yourself seated with highly accomplished scholars and students. In the law program, we have guidelines on marking expectations. And for most courses, those guidelines situate the average in a course at a 6.0 or B level, which means that the average in any given course should be at a B, subject to permissible deviations. On average, therefore, a student in our program should expect that their GPA will drop the equivalent of 10 percentage points relative to the grades that they earned in their undergraduate programs. For many of you, this will be a shock and quite discouraging. It is, however, the nature of legal studies. You are now in a smaller pool of highly accomplished scholars, marked to rigorous standards. You should therefore not internalize or take amiss the fact that many of you will exit the first-year program with grades on your transcript that you've never seen before. The second observation I'll make is that success in law school may require the deployment of skills that are unusual in your experience. The form of evaluation may be quite unique relative to what you've experienced in the past. For example, many law school courses are evaluated by what's known as hypothetical exams. And so in those hypothetical exams, you are asked to apply knowledge that you're expected to extract from what's known as the case method of study, and then apply that knowledge in unique circumstances that you've not encountered before to a particular set of facts that are presented for the first time to you on the examination. Let me unpack some of the elements of that particular form of evaluation for you. First, note my reference to the case method. In common law studies, the expectation is that students and lawyers should be able to read a case, that is, a judgment by a court, and discern in that case the key legal conclusions and findings. They are then expected to take those principles of law and be able to apply them, or not, as the case may be, depending on the interests of your client, to a unique and highly variable set of different facts in an effort to arrive at an outcome that favors the interests of your client. In other words, in traditional common law studies, you are expected to extract the rules yourself from the jurisprudence. You are not given a large tome which outlines in great detail the rules and how the rules can apply in every conceivable set of factual circumstances. Having extracted these rules, you are expected to synthesize them and then deploy them to new facts, new problem situations. This is a very difficult skill, being able to extract jurisprudence and then apply it to new circumstances. And students often struggle with this new skill on examinations, especially in the first-year program. Those who succeed on these examinations tend to hack the system, learn how it is that one can do this efficiently and effectively, and earn the marks associated with this skill set. I prepared a podcast on writing law school examinations that you may want to listen to early in your legal studies in order to hone those skills. Now, I hasten to add that not every course will be evaluated with an eye to a standard hypothetical examination. In fact, increasingly, your first-year courses will involve all sorts of other forms of evaluation and other skills being evaluated, including your capacity to write effectively in assignments and other forms of work product that you do outside of the classroom, and sometimes in the classroom itself. Which leads to a third observation. The coin to the realm is often a capacity to write effectively, efficiently, and with verve. Learning how to write well is one of the key aspects of performing well as a lawyer. And so if you find yourself struggling to write effectively and cogently, you should look to those programs offered within the law school designed to assist you with your legal writing aptitude. A fourth observation I'll make is that law school is a lot of work. It can consume every waking moment if you allow it to. You can spend endless amounts of time trying to understand the peculiarities of any given case that you're asked to read. Be wary, however, of the law of diminishing returns. There will come a point in which further study offers very little in the way of supplemental understanding. Do not lose yourself in law school by spending every waking moment in the library struggling with matters of incidental importance. One of the virtues of law school is the ability to involve yourselves in all sorts of extracurricular activities which help balance and round your experience and give you an opportunity to engage, for example, in matters of public importance and public debate. Take advantage of these opportunities. Do not let this time go by without experiencing some of the fascinating extracurricular activities in which you can involve yourself. Let me end this introductory podcast with some words on career development. One of the things that you will soon turn your mind to, if you're like the typical law student, is what will happen after law school. Most of you are, broadly speaking, familiar with the process of being admitted to the bar. Many of you have that aspiration. I will begin, though, by saying that not every law student comes to law school with the intent of being a practicing lawyer. Many do come with policy objectives and an effort to upgrade their credentials to work in some other dimension of life with a profound understanding of the way the law works. The law degree can be a door opener to those sorts of professions. For those who are inclined to practice law, the route from law school involves writing bar examinations and, at the time of this recording, apprenticing, or as the term goes, articling, with an articling principal, often in the employ of a law firm or, in some instances, as a law clerk assigned to a judge. Getting an articling job becomes a core preoccupation for law students relatively early in their legal studies. We have resources in the law school designed to assist in this articling job search process in the form of our Student Services Office. And they hold periodic job seeking sessions and job information sessions throughout the course of the academic year. You are strongly encouraged to attend those sessions and to tap into the expertise of the Student Services Office. As you enter your legal studies, there is a fair amount of debate about the future of the profession and how it will regulate itself or possibly be regulated by others. At this juncture in your legal studies, there is little benefit to worrying excessively about where the profession may go in the future. Your job is to do as well as you can in law, to experience the virtues and benefits of your presence in a law school, and to develop skills and aptitudes that will allow you to succeed in your chosen profession. There is a lot of information and also misinformation about the future of the profession and what it is that you should do to maximize your chances. My only advice on this is to speak to those who know what they're talking about and not necessarily fall prey to every rumor that circulates on social media. We have seats in our law program for 1 out of every 13 persons who apply to it. You have been given a tremendous opportunity to develop skills, aptitude, interests, and to perform public service for members of society. Enjoy your time in law school and take advantage of the virtues it brings. And so on that note, let me close this particular podcast. In the next podcast, we will turn to the substantive issues that this virtual orientation intends to address.